So thank you, sir, for a wonderful talk. It was very enlightening.
Thank you.
I have one or two questions. One question is, how optimistic are you about the Sabarimala verdict? I mean, review that is planned in the court. The second question is, how optimistic are you about the Supreme Court releasing all South Indian temples back to the Sampradayas?
The first question is how optimistic I am about the Sabarimala verdict. I'm not optimistic. Two reasons. 99% of the reviews do not favor the aggrieved. The same judgment comes, almost the same judgment comes. Reason number two, I was in Supreme Court watching the proceedings. I was there watching. So I don't think it will favor dharmic Hindus.
You have to be more specific. You are now leaving it in suspense for us.
No suspense. I was there watching the judges. I was there. Some of the lawyers argued incredibly well. First was senior advocate Pravasar. Lawyers worth mentioning are senior counsel Venkatramani and Abhishek Manu Singhvi. He argued beautifully. And our Indic Collective Trust mentor, Sai Deepak, it looked like they didn't want to give him time at all. Anyway, within 3 minutes, he did a rapid fire thing. He gave 4 wonderful reasons why this judgment should be reviewed. Subsequently, all these lawyers have filed written arguments. Okay, miracles can happen. But it is also the time that Ayyappa showed me some truths about the denomination, and I'm planning a separate Article 32 petition before the very same Supreme Court, because I can't file a case before the Ireland Supreme Court. I have to file it here. Let's see. As far as the government releasing the temples, or Supreme Court asking these temples to be released by the South Indian governments, Pujya Swami Jayananda Saraswati's case is regarding 2 states and 1 union territory, Tamil Nadu, Andhra, and Pondicherry. But whatever verdict that comes here, it will be applicable to all states which have similar laws or provisions. The case was filed in December 2012. Even the interim application is not being taken up. Our lawyers have been unduly busy in the last 4-5 months due to Sabarimala thing. So in March again we will pursue. I'm very hopeful in a matter of 2 or 3 years. The court has to come out with the obvious truth that government cannot be administrators of, a secular government cannot be administrators of a Hindu temple or temples.
Sir, I have almost 4 questions to you on the presentation what you have given.
Okay.
When we generally basis your inputs on the presentation, the consensus, if I can say so, is that we don't really understand the intricacies of the Supreme Court judgments and the belief overall whether they can give justice to us in terms of reclaiming these temples.
Mm-hmm.
So why are we insisting on a dispute resolution with courts again in the dharmic
matters? Okay, that's your first question.
First question. Second is, how do we stop constitution getting into the temple? Because the Tamil word which you used, how do you administer inside the temple? How do you administer outside the temple? How do we legalize that and protect it by, say, some vested interest who's just busy getting into our temples? Because the constitution doesn't define all those things. Inside temple, outside temple, some ritual can be disputed, somebody can be, I have seen...
Okay, that's the second question.
Second question.
Can I answer these 2 questions first?
Yeah.
Before I forget them? I mean,
no, I
will forget them.
Yeah, I can repeat it. Again, I am saying, how do we protect the rituals of a particular temple constitutionally?
Okay.
And fourth one is, why can't we empower mathas to be the first dispute resolution authorities constitutionally? We all understand mathas have their own...
Okay. Now first thing is, your question, first question to understand, why are we going to the courts again? Yeah?
Why are we depending on, or why are we proposing a structure where we are again going to courts?
When the Constitution came into force, 26 January 1950, the date is correct, unless I am the son of Karnataka M.K. Stalin. Okay. Most of our temples, or at least most of our big temples, they're already with government. So where do you go? And as soon as the Constitution came into force, the Madras government tried to take 4 temples: Guruvayur, Chidambaram, Udupi Sri Krishna temple, which is the Shirur Mutt case, and Mulkipeta Venkatramana Swami temple. Okay? They wanted to take all these 4 temples so that they would set an example, and all temples will fall under government. And Guruvayur, there was so much opposition, they gave it up. Then Chidambaram and Shirur Mutt was a common judgment in Madras High Court. Mulkipeta was again a similar judgment. These 2 judgments became 3 appeals before the Supreme Court. And they withdrew the case, they offered to withdraw the case in Mulkipeta and Chidambaram, but Supreme Court dismissed them. And only Shirur Mutt case was discussed, and denominations were defined and all that. Now, the 7-judge bench of the Supreme Court has been the highest authority, legal authority on religious rights, Article 25 and 26. So naturally, other courts, including Supreme Court, had to follow the rational dictum of the Supreme Court. Some very good judgments have come from Supreme Court. Unfortunately, because of the, in my opinion, the faulty definition of denomination, the Hindus were shortchanged or had a raw deal and all that. Now we have to go again. There's a saying in Tamil: if you fall from a ladder, you fall to the ground. If you fall standing, you fall to the ground again. You have to go to Supreme Court only. Where else can you go? As I said, I can't go to the Supreme Court of Ireland, where I have an excellent chance of getting a better judgment. But I can't go. Jurisdiction. Okay, that's one question. The second question is, Constitution is not getting into your temples. Government is getting into your temples. In the name of Constitution, some of the judgments are allowing it. It is only the government. Now, can the government try and get into a mosque? Can the government try and get into Velankani Church or St. John's Church or whatever? The opposition will be severe. We Hindus, we are only worried about our daily, not our daily bread, but our daily Dahi sadam. We have it, and we think the kings were administering our temples in those days, so government is entitled to administer temples. We forget that the kings were dharmic persons who followed Hindu Sampradayas. And the truth is, they never administered the temples. They, after building Tanjavur Bragadishwara temple, the king gave it, pouring water to the community. That is there in the inscriptions. Every temple was like that. They never had ownerships of temple. Of course, they will oversee. Overseeing and ownerships are 2 different things. Constitution is not getting, but your question assumes a lot of significance vis-a-vis Dahi Handi, vis-a-vis Sabarimala temple, vis-a-vis Diwali crackers. Yes, your question assumes a lot of significance. But again, it's not the Constitution, it is the interpretation of the Constitution. How can Constitution protect our rituals?
Rituals and
See,
I'll give 2 examples.
One.
Apart from the Sabarimala, which we understand and things like that, I've seen one of the posts on Twitter, temple outside Malaysia or Indonesia writes in all languages saying that menstruating women should not enter the temple.
I have a photo which I took in July in Trikonamali in Sri Lanka.
Similarly, I have grown up when I will not touch the priest while taking prasadam or taking tirtha. He is supposed to be in Telugu, what we say, he is in a muddy, he perform. Now, I can see a scenario where somebody will thrash that person who says you should not touch him, leave alone the priest. Priest anyway gone. But person who stands up and says this is our ritual, then there will be a constitutional scenario. So we are like trying to say that
I understood your point. You were adding something, sir.
This adds to The stupid or not stupid essentiality
Okay.
to a religion. That problem.
Yeah. See, again, the Shirur Mutt judgment, the seventh judge, is talking really well about how to determine what are matters of religion. It gives a very lucid explanation. What is a matter of religion had to be seen only from the tenets of the religion. If somebody is following the Ayyappa Sampradaya, whatever rules that have been ordained for that Sampradaya, they only will decide what is the core essential thing. What may be essential for one sect may not be essential for the other sect. What may be essential for one sect may be downright wrong in the other sect. So, we are actually protected under the constitution for that, because the article 26b says decide their own matters in when it comes to religion. We can. But over the years, courts have started interpreting them, and they even talked about superstitions and all that. Court is no person to say this is superstition, this is not superstition. Will the court declare, suppose I file a case tomorrow, 10 of us, not only I, 10 of us, who are not Christians, like women did in Sabarimala matter. They are not devotees. They file a case. I file a case. Nowhere in the Bible we see that 25th December is the birthday of Jesus. Celebrating and preaching that he was born on that day is downright fraud. So, Supreme Court strike this down. Will Supreme Court do it? It will say, no, this is a matter of faith.
Why don't we do it?
Supreme Court will say it's a matter of faith. If you have any doubts on Christians being denomination, refer to Oxford Dictionary, it will say. What is a matter of faith cannot be deliberated by any court, be it a Supreme Court or something. Supposing there is a dispute among Hindus themselves. Let's say, this festival should be done on Ashtami, not Navami, something like that. Something to do with the traditions or custom. Then there is a court called a civil court, a trial court, where before a trial judge, you adduce evidence. In Tamil, those days, the 12th century, there is a song, Aachiyil Avanathil Ailartham Kaachiyil. Aachiyil means that which is by law. Avanam means document. Okay, there is some recorded sastra or book or something you follow, or inscription. Law, document, Ayalartham Kachi, or witness. My great grandfather is 97 years old. He says, no, this was celebrated only on Ashtami. And the court is inclined to accept his evidence. So, even in Sabarimala, if this is an essential part of the religion, only a trial court could have decided, and not a writ court is seen in the arguments of many of the councils. So that answers your questions. The constitution is not coming into rituals. The court's interpretations are coming. And even when you have to decide what is the core essential thing, it should be done with the tenets of the religion, practice of the religion, evidence, and it could be done between the Sampradaya people and not by outsiders.
One is the Mata superior.
Matas. See, that is where I came to the Dharmic Parishad. Each Mata has its own Sampradaya. Vaishnavite Mata, Tengale Vaishnavite. This Mata belongs to this Linkayat community. This Mata belongs to the Matwa community. And within them there are divisions. So, if you have a dispute on a particular Sampradaya, ideally you should take it to the Matadipati of that Sampradaya, who is there as a representative of the community, and whose, I won't say job, I won't even say duty, whose dharma it is to teach the philosophy. It is the proper thing to do. I agree with you.
Why can't it be transferred to Matas rather than?
Not the temple should not be transferred to Matas. No, that should always belong to the communities. There are special reasons for that. Unfortunately, I can't say that now. Matas is only for the teaching and sustaining the particular philosophies. and building a Shishya Parampara. So Matas today have hospitals, schools, and all that. That's a different thing. They are general dharmic things. But I feel, and Matas also have temples, their own temples. There they can do. Elsewhere, they're not supposed to take over temples. They can be guiding lights. Yes, sir?
As you said that based on some like they should be belong to certain community and all, they have to be in the administration. So I don't see anywhere that based on the spiritual level or the bhakti towards that temple, that deity, they should be given an administration power. That was my one question. And other question is not regarding the framework. In the present situation, the basic thing why this we are facing this present situation is because there is no dharma shikshana among the Hindus. How can we encounter the present situation? How can we give that education? What channel can we use? These were the two questions.
Okay, the community, the Sampradaya, you have to presume that they have enough devotion. You can't actually measure the devotion of each person by his or her outward actions or sayings. That is one thing. You have to see if this person has led a dharmic life, has not cheated anybody, has been generally good. That much only we can go. We can't actually measure devotion. He is a regular temple visitor. She is doing seva for the temple regularly. She has kind words. She does not get into dispute. She is not a problematic person. He is not a problematic person. Those are the outward signs you should look for. Beyond that, it is difficult, practically difficult. How do you measure one's bhakti?
Exactly. So a person who is into the devotion, he may not be belong to a certain denomination, right? He may even be someone who is a local.
Yeah, a Shiva Bhakta may not belong to the exact denomination to which the temple belongs. He may be a great Bhakta, but he can't be in the direct administration in the framework we are talking about. He may be included as special invitees or people who we want them to be part of the board. See, we should give representation to all castes. It should not be caste based. It should not be even gender based. It should be qualification based. But at the same time, we should ensure certain castes are not left out. Supposing in a town, 60% of the people belong to a particular caste. Either way, they should not hog the entire board. Or none of them are there in the board. It's also not a good scenario. We should find out who is the most qualified among them. And especially those castes who are in the scheduled caste, all that. We should not leave them out. There have been great bhaktas in each state, Karnataka or Tamil Nadu, from the Dalit community. Great saints have come. So, they should be also included. Community should be given place. Women should be given place. And it's all qualification based.
Sir, I have two questions for you.
Yeah.
With respect to Sabarimala wedding topic.
Suppose in case Supreme Court declines to for the review, so what is the possibility for the central government to bring an ordinance wherein we do we need any help from the state government, as we do not expect any help from their end. Second question is again with regard to Sabarimala itself. So when the state government was bringing the non-Hindu women into Sabarimala temple, Sri D.G. Mohandas filed a case against that. So when the Kerala government filed an affidavit stating that Sabarimala is a secular temple and there should be a larger discussion about it. So what I think is, it could be a secular temple, maybe we don't have anything as such in constitution, it would form a secular one. And in that case, that could be a new religion altogether, right?
Okay, answering your first question, what can the central government do? The central government can do much more than what it is doing now or what it is not at all doing now. We must remember the subject of temples or religious institutions or religious charities is a concurrent subject in the constitution, which means both the central government and the state governments can legislate on it. The central government's legislation will be on a higher pedestal than the state government, which is what we saw in Jallikattu matter. Because of central government, Jallikattu was banned. Because of central governments, Jallikattu came back. That is the truth, because it was also a concurrent subject. Now, today, all central government has to do is define denomination as Sampradaya. They have an act called Places of Worship Act. There is also two provisions there which says whatever be the denomination of the temple as on August 15, 1947, it should not be changed or it should not be diluted. So, the impact of the Supreme Court judgment is it belongs to the Ayyappa Sampradaya following a particular observance or faith. It is sought to be diluted. Second, whatever was the religious character, section 4 of the Places of Worship Act, whatever was the religious character of the place of worship, be it a Shia mosque or a Sunni mosque or a Protestant church or a Hindu place of worship like Sabarimala, whatever was the religious character on 15th August 1947, it should not be changed. So government should easily in their own act just add 2 lines saying defining religious character. Don't leave it to the courts. Court is saying no. You're just Hindus. You don't have any special religious character. People who go to Sabarimala. That is one thing. Second question yours is like. Sorry? No. See, the case was filed by non-devotees. It's very clear. People who had no locus, no intention of going and worshipping Ayyappa. Case was filed to create confusion because Sabarimala is attracting more than 1 million devotees every year and more devotees are coming. And Kerala, which is slowly becoming a Hindu minority state, is getting a large influx of Hindu devotees year after year after year. Some forces, including the communist forces in Kerala, did not like it, and that's why the case. So, Sabarimala, the Kerala affidavit says it's a secular temple. I'm saying the Kerala government is an atheist government. How can an atheist government give an affidavit about a temple? I have filed a case in Kerala against the Kerala government, against Pinarayi Vijayan, against the Travancore Devasam Board. My main thing is the Kerala government has absolutely no stand, no authority as per the Travancore Cochin Religious Institutions Act. They should keep away. They have no locus standi. Ask them to shut up. That is my case. After my case was filed, much of the power of the Travancore Devasam Board was curtailed by the Honorable Division Bench. They have appointed 2 retired judges and 1 police officer. And any major decision the Travancore Devasam Board has to take has to be in consultation with them. We need not go by the whatever affidavit. There's no such thing as secular temple. As I said, is the Bishop of Kottayam coming there? Is the Imam of Kanjarapalli is coming there and doing the pujas? It is the Tantri who is doing the pujas. We have to do 3 things. We Hindus have to do 3 things. Be aware. Beware. We have to be aware of the forces which are trying to destroy us. We can't be eating curd rice and sleeping. Okay? Second, and be aware and spread the awareness. 3, when I say be aware, the Constitution gives us 3 rights under religious rights: profess, practice, and propagate. Today, a Hindu, he looks here, looks there, and if he's among Hindus, he says, yeah, I'm a Hindu too. Otherwise, he doesn't say that. Practice is strictly curtailed because government has our institutions, including matas, all our charities. There is a Raja Chatram in Tanjavur district, which was endowed as a Hindu religious charity by Raja Sarfoji, Maratha king. It has 33,000 acres. That charity is with the collector of Tanjavur today. And he's saying only 2,000 acres are left. Can somebody eat 31,000 acres of, simply gobble it up?
You gave it to charity.
It hurts to laugh. Okay, now be aware, be vigilant, agitate when you have to, and file cases like yours truly does.
It's actually, Ramesh, oxymoronical to say secular temple. Secular and temple doesn't go together, even according to your dictionary terms. Thank you.
Okay, Mr. Srinivasan was making a statement, very important, valid statement.
Okay, what will happen to the Padmanabha-Swami treasures once the government leaves its control?
We have, a very, very ardent devotee of Padmanabha has come out with a very, very good solution. His name is Jacob Maplesheri, but an absolute devotee of Padmanabha Swami. He has suggested, he has filed an application before the Supreme Court by which the 500,000 crore rupee worth treasure, even by the gold value or other value, it is worth 200,000 crore rupees. It is kept there like it is kept in Fort Knox, the security improved. Union government guarantees that amount to be returned, and RBI treats it as its own vault. The gold is not moved out of it. RBI treats it as gold deposit and issues bonds or quasi-currency based on that gold with the central government backing. And that 200,000 crore rupees, which anyway Modi ji has been asking RBI, I want 200,000 crore rupees, here it is. Padmanabha Swami is giving you, provided you guarantee it, take this 200,000 crore rupees, issue bonds or issue quasi-currency, use it for your infrastructure works or other banking purposes, improve the society, but give Padmanabha Swami 5% tax-free interest, which will translate to 10,000 crore rupees per annum. And Kerala will have Hindu schools, Hindu hospitals. They will not go to St. Joseph's College or Alfonsa School for women, not anything, their own hospitals. And it will be a good thing, which is what the communist government does not want to happen. The gold being discovered, the gold is not 300, 400-year-old gold. We have parts of Roman coins, 2000 years old. This has been maintained by the Chera kings as Padmanabha Swami's wealth. Okay, now that it is discovered, it needs to be protected and it can help the community improve. Thank you very much. Jai Shri Padmanabha.